It is in that context, my lord, it was held in Pramati. The lordship may now come to now. Before that, my lord, I'll take a lordship to the statement of objects and reasons in the Right to Education Act. Kindly have a look at it, then, my lord. That will show it's a package which includes section 12, 23, everything will, which forms a package. Now, my lord, the statement of objects and reasons, my lord, after the introduction, my lord, the second paragraph. The crucial role, your lordship has got it, the crucial role of universal elementary education for strengthening the social fabric of democracy through provision of equal opportunities to all. The crucial role of universal elementary education for strengthening the social fabric of democracy through provision for equal opportunities to all has been accepted since the inception of our republic. The directive principles of state policy enumerated in our constitution lays down that the state shall provide free and compulsory education to all children up to the age of 14 years. Over the years, there has been significant spatial and numerical expansion of elementary schools in the country, and the goal of universal elementary education continues to elude us. The number of children, particularly children from disadvantaged groups and weaker sections who drop out of school before completing elementary education remains very large. Moreover, the quality of learning achievement is not satisfactory, even in the case of children who complete elementary education. Article 21A, as inserted by the Constitution, provides for free and compulsory education of all children in the age group of 6 to 14 years as a fundamental right in such manner as the state may by law determine. Consequently, right to free and education bill 2000 it is proposed to be enacted, which seeks to provide that every child has a right to be provided free and full-time free elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. Compulsory education casts an obligation on the appropriate government to provide and ensure admission, attendance, and completion of elementary education. Free education means that no child, other than a child who has been admitted by his or her parents to a school which is not supported by the appropriate government, shall be liable to pay any kind of fee or charges expenses which may prevent him from pursuing and completing elementary education. D is important, Lord. The duties and responsibilities of the appropriate governments, local authorities, parents, schools, and teachers in providing free and compulsory education. So therefore, my lord, D is very important. It is by virtue of D, my lord, section 23 has been introduced. There are other provisions also. Therefore, my submission before your lordship is that this is a law which is enacted to give effect to free and compulsory education. Section 23 and other provisions are only incidental and ancillary to section 12 and section 3. Therefore, my lord, it is that is what is contemplated in the statement of objects and reasons. Therefore, now, my lord, I'll just take your lordship to Pramati, my lord. Would your lordship?
Mr. Chacko.
Yes, my lord.
You read para 2 of the statement of objects.
Yes, my lord.
Just go back to the last sentence in that paragraph that you read.
Yes, my lord. Para 2. Article 21A is inserted.
Moreover, last sentence.
Yes, moreover, the quality of learning achievement is not always entirely satisfactory, even in the case of children who complete elementary education.
So this is also about quality of education.
Now, my lord, I am only showing this whether 23 can be severed from section 12. Now, my lord, as far as quality of education is concerned, as I said the other day, my lord, it is open to the state or the center to pass appropriate law to ensure that teachers are having certain standards. That is being done. That is already done in the state of Tamil Nadu. Other states are also it is done. That is permissible under entry 25 of list 3. Either the central, now today your lordships are only considering whether that can be done through a law which is enacted under 21A. Whether 21A permits that exercise. That's the only thing which I am submitting before your lordship.
No, what makes you think, Mr. Chacko, that while enacting this act, they have restricted it to Article 21A. They have also used their legislative power under list 3.
No, they don't have any such case, my lord. Even the central government does not have any such case. Even in Pramati.
Forget that. See, when a power is exercised, we have to trace the power. It doesn't matter what nomenclature they use. It doesn't matter what nomenclature they use.
If that be the case, my lord,
a wrong provision is invoked. But if we find the power, we say you have the power to do it.
No, my lord, if that be the case, my lord, none of the state legislature will be able to enact any law under entry 25 providing for TET, my lord. Now the states are actually doing it.
They can make something.
An exercise. Then, my lord, there will be a conflict between the two, my lord. Now,
why will there be a conflict?
Now, my lord, my lord, what I am submitting is, in pith and substance, my lord, this is a legislation providing for free and compulsory education as envisaged under Article 21A. So therefore, my lord, the Constitution Bench was only called upon to consider whether that law contemplated under 21A would take in minority institutions. Now, therefore, my lord, it is in that context, my lord, the 5 judges of this honorable court considered and said, no, the law contemplated under 21A cannot include minority institutions. It is in that context, my lord, the Constitution Bench also said the neither aided nor unaided minority institutions will come within the ambit of 21A or 15.5. 15.5, even otherwise, it is very clear. I will go to 15.5 later, my lord. So, would your lordship kindly see, my lord, what the Constitution Bench has held in Pramati, my lord?
Mr.
Yes.
Chacko, we'll
Yes,
come back to that. No problem.
Yes.
Just turn to the RTE Act.
Yes,
See
my lord.
its width, see its amplitude. You are mistaking it only to free ship.
Yes, my lord.
See, free ship obligation, we can understand it should not be cast on minority institutions. But for instance, just turn to section 70.
Yes.
It says prohibition of physical punishment and mental harassment to child. Can you say
No.
that you will violate this provision and
That
apply
is,
institution?
no, my lord, that is already there in all state education acts.
We are just asking you. No, we are
Yes.
just testing the provisions.
No, I'm not saying it. I will not say it will not apply.
Therefore, 17 applies to you.
17 will.
That is the prohibition on punishment on children.
No, my lord, 17.
Can you say that I am a minority school in terms of?
No, I will not say that. What I am saying is,
If you can't say that, how can you say that 23?
no. What I am submitting, my lord, this cannot be. Now, my lord, what is actually
Look
included?
at section 18. No, what we are trying to tell you is please
Yes.
appreciate the width and amplitude of this statute.
Yes.
It's a very comprehensive statute dealing with education.
Education.
Elementary education. It's one of, see, yeah, in post-modern era, I think this is one of the most positive legislations that we have seen from Parliament.
Correct, my lord.
And
Now,
we should not dilute it. No, we should.
No,
in fact,
now, my lord, all these
ensure
provisions.
that it confers the rights on the child.
Correct. Now, my lord, all these provisions which your lordships have pointed out. Yes.
One of
All
the most
these
forward-looking legislation we have seen in recent times. Just turn to section 18. Just
Yes,
turn to
ma'am.
section 19.
Yes, my lord.
Norms and standards for schools. Can you say that you will not follow these norms and standards? These are general norms and standards, no?
Now, my lord, I'll tell your lordship.
In fact, your institutions are also performing a human service for the
Yes.
society at large.
True.
When you are doing that, how can you say that you will not comply with these small safeguards which have been inbuilt in this act?
Now, my lord, what I am submitting is something else, my lord. All these things are either done by the state or the center through other legislations.
No,
Today, my lord, this
You
is a
cannot
legislation.
frame a separate regime altogether.
no, for instance, turn to section 25.
Yes.
There is a pupil-teacher ratio. You will not comply with this.
Now, my lord, these are all.
See, Mr. Chacko, what we are trying to tell you is this is a very wide legislation. It is not restricted to just free and compulsory education under Article 21A. It is very, very wide. It's talking about quality of education. It wants to improve the school infrastructure. It wants to change the way students are taught in school.
Now, my lord, even the learned Attorney General has submitted before your lordship, my lord, that all these provisions are actually emanating from Section 12. It is part of, therefore, my lord, it is a package. Even the central government does not have such a case, my lord. Now, my lord,
No, that is not the That is not
that is
it.
what the learned Attorney General has stated in the written submission. What the learned Attorney General has submitted before your lordship, my lord, because it is a different legislation, my lord, enacted for a different purpose. Therefore, my lord, your lordship has seen, my lord, Section 3, my lord. Kindly see,
So
my lord,
what we are
Section.
asking you is, see,
Yes.
you are saying this act is non-severable. We are telling
Yes.
you these provisions can be easily segregated and severed.
No, I'll tell
Why
your
can't
lordship,
it
my
be
lord.
severed when we say that there is a pupil-teacher ratio?
No,
This is like an island in itself.
Now, my primary submission to your lordship, as far as that is concerned, my lord, if it is a legislation under 21A, my lord, then the question of severability does not arise. Now, my lord, that is a mistake which was
We can't
committed in
hear
the
you, Mr.
Rajasthan
Chacko.
school case. Yes, my lord.
Can't hear it.
Yes, my lord.
Hi.
Now
you're
you're
back.
comfortable.
Yes, my lord. Now, my lord, what I beg to submit before your lordship is a law made under 21A stands on a different footing from a law made under entry 25 of list 3 or entry 66 of list 1. These are all fields which are left to
Can
the
it not be
parliament.
complementary?
It can be, my lord, it can be. But once a constitutional bench of this court, after considering the entirety of the act, has come to the conclusion, my lord,
You
the
show
act.
us that the entirety of the act has been considered in Pramati.
No, this is what I'm submitting, my lord.
17, 18, 19, 23, 25, 26, these have been considered, show us.
I'll tell your lordship, my lord, the reason why it was not separately considered is this forms part of actually the section 21A. 21A provides for free and compulsory education. Therefore, if a legislation is enacted to implement section Article 21A, my lord, there is no need to go into other aspects, because the other aspects are only incidental to the main objective of providing free and compulsory
The
education.
main object is education.
Yes, free and compulsory education.
Education to children.
No, my lord, education may not be, my lord. Your lordship will see, my lord, even
And,
in the statement of objects, it is actually free and compulsory education. That is what is stated in the statement of objects. That is what is stated by the Constitution bench. So, my lord,
And with the introduction of clause K in 51 capital A, it
yes,
becomes the duty of every parent and guardian
correct,
to provide
correct,
opportunities for education to his child.
correct.
Right? All have
Yes.
to be.
No, correct, my lord. Now, my lord,
And whatever is for the benefit of the child, that has to be sought to be achieved.
correct. Now, my lord,
Right?
I understand
Now,
the
the way
sentiments of your
courts
lordship.
have looked at Article 30. There needs a relook in view of 21 capital A, which itself is a fundamental right.
I'll tell your lordship, my lord. Now, my lord, now, my lord, that is a matter which, my lord, has
You
has
cannot,
gone-
perhaps we would be surprised if a submission is made that 21 capital A is violative of Article
No,
30.
I didn't say that, my lord. What
No,
I
you
said is,
didn't
my lord,
say. We said
yes.
that we would be surprised if such a submission is
In
made.
fact, in fact, the Constitution bench itself said 21A is valid, 15.5 is valid.
A has to be valid.
Now-
On
now-
what ground would this court,
Yes,
can you
my
by any stretch of imagination say that there is some scope for declaring 21 capital A as
No,
violative
no,
of
not at all. Not at all, my lord.
30?
Now, my lord, therefore, what the Constitution bench looked into is only whether the law contemplated under 21A is consistent with Article 30. And therefore, my lord, the Constitution bench considered. Constitution bench did not go into other provisions of the Act for the reason that the objective of the Act was to provide free and compulsory education. Therefore, if that cannot apply to minorities, my lord, there is no need to go into other provisions of the Act. This is the reason, my lord, the Constitution bench did not specifically deal with other provisions of the Act. Now, my lord, would your lordship kindly see Pramati, my lord? Now, my lord, Pramati, para 48 onwards, the Constitution bench was, I'm sorry.
Is it in volume 1, volume 2?
No, my lord, I'm not aware, my lord.
Lordship, it's in volume 2.
Volume 2.
Okay, 768. Volume 2, page 768 is
The
there.
judgment begins with the
Para 48, my lord, the court is actually considering the history of this particular provision, the Article 21A. I'm not troubling your lordship with that. Your lordship may come to page 266. Just the para above 49. Para above 49. It will thus be clear that the statement of objects and reasons extracted above, although the directive principles in Article 45 contemplated that the state will provide free and compulsory education for all children up to the age of 14 years within 10 years of promulgation of the Constitution, this goal could not be achieved even after 50 years, and therefore a constitutional amendment was proposed to insert Article 21A in Part 3 of the Constitution, bearing in mind this object of the Constitution, 86 Amendment Act, inserting Article 21 of the, we may now proceed to consider the submissions of the Learned Council for the parties. Article 21 of the Constitution, as we have noticed, states that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. The word state in Article 21 can only mean the state which can make the law. Hence, Mr. Rodge and Mr. Nariman are right in their submission that the constitutional obligation under Article 21 is on the state to provide free and compulsory education to all children of the age of 6 to 14 years and not on private unaided education institutions. Article 21A states that the state shall by law determine the manner in which it will discharge its constitutional obligation under Article 21A. Thus, a new power was vested in the state to enable the state to discharge this constitutional obligation by making a law. However, 21A has to be harmoniously construed with 19(1)(g) and 31 of the Constitution has been held by this court. Then next paragraph. We do not find anything in Article 21A which conflicts with either the right of private unaided schools under 19(1)(g) or the right of the minority schools under Article 30 of the Constitution. But the law made under 21A may affect the rights under 19(1)(g) and 31. The law made by the state to provide free and compulsory education to the children of the age of 6 to 14 years should not therefore be such as to abrogate the right of unaided private educational schools under 19(1)(g) of the Constitution or the right of minority schools aided or unaided under Article 30 of the Constitution. Well, now, my lord, your lordship may come to para 51. In our considered opinion, therefore, by the Constitution 86 Amendment Act, a new power was made available to the state under Article 21A to make a law determining the manner in which it will provide free and compulsory education to the children of the age of 6 to 14 years, as this code contemplated in the directive principles in Article 45 before this constitutional amendment could not be achieved for 50 years. This additional power vested in the Constitution Act 2002 in the state is independent and different from the power of the state under Article subclause 6 of Article 19 of the Constitution and has affected the voluntariness of the right under Article 19(1)(g) of the Constitution. By exercising this additional power, state can by law impose admissions on private unaided schools so long as a law made by the state in exercise of this power under Article 21 of the Constitution for the purpose of providing free and compulsory education to the children of the age of 6 to 14 years, and so long as such law forces admission of children of poorer, weaker, and backward sections of the society to a small percentage of the seats in private education institutions to achieve the constitutional goals of equality, etc., etc. To give an idea of the goals of Parliament intended to achieve by enacting the 2009 Act, we extract para 4, 5, and 6 of the Statement of Objects and Reasons, which was enacted as the 2009 Act here and below. The proposed legislation is anchored in the belief that the values of equality, which I have already read out, my lord. Then, my lord, last paragraph. It will be clear from the aforesaid extract that the 2009 Act intended to achieve the constitutional goal of equality of opportunity through inclusive elementary education to all, and intended that private schools which did not receive government aid should also take responsibility of providing free and compulsory education of satisfactory quality to children from disadvantaged sections of the and weaker sections. Then 53. When we examine 2009 Act, we find that under 12(1)(c), read with section 2 and 4 of the Act, an unaided school not receiving any kind of aid or grants to meet its expenses from the appropriate government or the local authority is required to admit in class 1 to the extent of at least 25% of the strength of that class children belonging to weaker section and disadvantaged group in the neighborhood and provide free and compulsory education till its completion. We further find that under 12(2) of the 2009 Act, such a school shall be reimbursed the expenditure so incurred by it to the extent of per child expenditure incurred by the state or the actual amount charged from the child, whichever is less, in such manner as may be prescribed. Thus, ultimately, it is the state which is funding the expenses of free and compulsory education of the children belonging to weaker sections and several groups in the neighborhood, which are admitted to a private and aided school. These provisions of the 2009 Act, in our view, are for the purpose of providing free and compulsory education to children between the age of 6 to 14 years and are consistent with the right under Article 19(1)(g) as interpreted by this court in TMFI and are meant to achieve the constitutional goals of equality and the opportunity in elementary education to children of weaker and disadvantaged sections. We therefore do not find any merit in the submission made on behalf of non-minority private schools that under 21A of the Constitution 2009 Act violate their right under 19(1)(g) of the Constitution. Under Article 30 of the Constitution, all minorities, whether based on religion or language, shall have the right to establish and administer education institutions of their choice. Religious and linguistic minorities therefore have a special constitutional right to establish and administer education institutions of their choice. And this court has repeatedly held that the state has no power to interfere with the administration of minority institutions and make only regulatory measures and has no power to force admission of students from among non-minority communities, particularly in minority school, so as to affect the minority character of the institution. Moreover, in Keshavananda Bharati versus State of Kerala, Sikri Chief Justice has even gone to the extent of saying that Parliament cannot, in exercise of its amending power, abrogate the rights of minorities. To quote the observations of Chief Justice Sikri in Keshavananda Bharati, etc., etc. Now, your Lordship may see next paragraph. Thus, the power under 21A of the Constitution vesting in the state cannot extend to make any law which will abrogate the rights of the minorities to establish and administer education to children. So, my lord, I am
Mr.
pausing here for a
Chako,
moment.
this
Yes.
broad statement, this
Yes.
broad statement after the quotation has to be read in the light of placitum F and paragraph 54, that you can only make regulatory measures, you cannot force any admission.
Yes.
It's in the same paragraph, therefore this broad statement has to be read limited to what has been said just above the quotation. You can
Governor-
regulate, you cannot
Yes.
force admission. Therefore, what was under consideration of the CB was whether by reason of 12, you can force the minority institutions to reserve a certain percentage where even non-minority students would be getting admission.
I'll just make good my
This is
submissions,
the
my lord.
proper way of reading the judgment.
No, my lord, no, my lord, my submission
Unless you
before a
can show
lordship
us
is.
something else that
No, my lord.
the CB did not have this in mind. CB wanted to lay down the law that RTE Act in its entirety does not apply to minors.
No, my lord, my submissions, my lord. CB
Then
considered two aspects.
we are coming to the concluding part, 55 and 56.
Yes, 55 I'll read out. When we look at the two,
Just place it, we will again show to you that
Yes,
the
ma'am.
first part refers to 12,
Yes,
second part only says 2009 Act. It does not refer to a particular section. But you have to read the entire paragraph.
yes, I'll read para 55, my lord.
The text must match the
Yes, ma'am.
context.
Yes, ma'am.
Just
Para-
because, in the second part of para 55, there
Yes,
is no reference to 55, no reference to 12,
Yes.
does not mean that the entire act has been excluded. Please place 55.
Yes, ma'am. When we look at the 2009 Act, we find that section 12(1)(b, read with section 2 and 2, provides that an aided school receiving aid and grants, whole or part, or its expenses from the appropriate government or the local authority has to provide free and compulsory education to such proportion of children admitted therein at its annual recurring aid or grants so received bias to its annual recurring expenses subject to a minimum of 25%. Thus, a minority aided school is put under a legal obligation to provide free and compulsory elementary education to children who need not be children of the members of the minority community which has established the school. We also find that under section 12(1)(c) read with 2 and 4, an unaided school has to admit 25% of the strength of class 1 children belonging to weaker sections and disadvantaged groups in the neighborhood. Hence, unaided minority schools will have the legal obligation to admit children belonging to weaker sections and disadvantaged groups in the neighborhood who need not be children of the members of the minority community which has established the school. While discussing the validity of clause 5 of 15, we have held that members of the communities other than minority community which has established the school cannot be forced upon a minority institution because that may destroy the minority character of the school. In our view, if the 2009 Act is made applicable to minority schools, aided or unaided, the right of the minorities under Article 31 of the Constitution will be abrogated.
This takes
Therefore-
further from the discussion preceding it. 12(1)(b)
Yes.
read with 2 and 2
Yes, my lord.
does not extend to any other provision of the RTE Act.
No, my lord. Therefore, 2009 Act, insofar
Right.
as it is made applicable to minority schools, referred to in clause 1 of Article 30 is ultra vires the Constitution.
Yes. This is creating the difficulty. You
Yes.
only discuss 12 and 2 and 2 and thereafter make it broadly applicable to all minority institutions that RTE need not be followed. Does it follow from this? You have to show that the logic that has been given leads to this conclusion. There is a connection. No other provision is considered.
No, my lord, I'll submit, my lord.
If you had been filed, I would be thinking that the learned judges would have clarified it, that it should not be read in this manner. They never intended it to be so.
No, my lord, let me just submit, my lord. No, my lord, what the court was considering was whether the law contemplated under 21A can march over Article 30. They said no. Therefore, and not only that, this is a law which is
There is
enacted
no
to.
question of 21 capital A marching over. We have to reconcile the two.
Yes,
We
sir.
cannot say that 21A is higher than 30 or 30 is
No,
higher than 21A.
Law
Your
contem-
30 in the change context,
Yes,
you have a right to administer and establish educational institutions.
Yes, my lord.
You have a right to establish, but what education would be imparted, how the teachers are to be recruited, what are the ancillary things that has to be followed, that is provided by 21 capital A. How can you say that irrespective of 21A, you have the right?
Now, my lord, what I am submitting, my lord, is the word law. The Constitution bench was actually considering whether the word law in Article 21A can violate Article 30 of the Constitution. In that context, not only that, the law was actually enacted. Law was actually enacted to give effect to 21A. What is 21A? 21A is an obligation on the state to provide free and compulsory education, for which purpose, my lord, Parliament passes a law. Then, my lord, the Constitution bench considers whether that law, which consists of 12, 13, 21, and 23, etc., can violate Article 30. My lord, the court said, my lord,
Right.
it can't.
12 was found to violate 15.5.
Yes, correct.
Right?
That's
so
right.
In that context, bearing in mind 15.5, 19.1G, 21A, and 30, the court said that 12 is ultra vires.
Now, my lord, I'll tell you a lot. Yes.
When there is no argument
Yes,
on the entirety of the act, it cannot operate as a precedent even.
now, my lord, yes, my lord.
Put the
Now,
entire 1990. Anything said by the Supreme Court on a point which is not argued is not a precedent.
yes. Now, my lord, my submission is, my lord, if that be the case, my lord, there was the Constitution bench could have very well said 15.5 does not permit this legislation, therefore it is ultra vires 15.5. There was no need to go into 21A because 15.5 is very clear. It can't apply to minorities. But Constitution bench goes further and considers whether the law contemplated under 21A can apply to minorities.
Not the entire law. Sir, you are making a mistake. 12.1B, 12.1C. These are the only two provisions of the RTE Act that is referred.
In fact, my lord, the
Why should we
Constitution.
assume that other sections which we have just now pointed out to you,
Yes, my lord.
17, 18, 19, 23, 25, 26,
No, my
these are
lord.
considered not a whisper.
Yes, my lord. Now, my lords, my submission is, my lord. Yes,
Mr.
yes, my
Jacob,
lord. Yes, my
just
lord.
come to page 769 of this judgment, or page 244 of your, if you're reading from the SCC.
Page
Page 244.
240.
Just turn to para 5.1 and 5.2. That's the question phrase.
Right, this is the question.
Yes.
Framed is whether Article 15.5 is constitutional and whether it abrogates the basic structure of the Constitution, and
Correct.
whether Article 21A abrogates the basic framework
Correct.
of the Constitution.
Correct.
They are not even considering any specific provision of the RTE.
RTE.
They are only
Now-
considering whether these two constitutional amendments are they legal or not, and whether they amount to abrogation of the basic structure of the Constitution.
Correct. Now, my lord,
That's the point we consider.
yes. Now, my lord,
We
15.5.
see it from that prism.
Correct. I'll explain it, my lord. True, your lordship is right. No, but the Constitution bench was only seized of the reference, which is validity of 15.5 and 21A.
Correct.
Now, my lord, 15.5 says state cannot make any law which provides for reservation to minorities. So, in
Yes.
that context, my lord, the Constitution bench was called upon to consider whether the RTE Act can survive Article 15.5. Similarly, my lord, the 21A says the state has to make a law to provide for free and compulsory education. Therefore, my lord, the Constitution bench had to incidentally consider whether the RTE Act, which is enacted pursuant to 21A, is ultra vires Article 30, is ultra vires 21A. Finally, my lord, the Constitution bench says, my lord, the Act is ultra vires 15.5, 21A, and 30. So,
To the extent that it forces minority institutions to admit students not belonging to the same community.
now, my lord, in which case, my lord, I'll just take your lordship to the Society of Rajasthan, my lord, where, my lord, this question was squarely an issue. Now, my lord, I'll straight away take your lordship to the three judge bench of this honorable court in Rajasthan case. There, my lord, this issue cropped up. There, my lord, the sole issue was actually RTE Act is ultra vires Article 30 of the Constitution. Your lordship may see, my lord. Now, my lord, your lordship may kindly come to para 33. Para 33, sixth line.
Which volume is that?
I think it is volume 2 only. This is 2012 6 SCC. Page 1.
My lord, it's in volume 3, page 58. Volume 3, page 58.
Lordship has got it. Para 33, my lord.
Just 1 minute.
Yes, I'm sorry.
Page 58. Come to page 91. And the very page 91. Yes.
Para 33. Now, my lord, while considering the applicability of the Act under 19(1)G, my lord, this is what is stated, my lord. Sixth line. The 2009 Act has been enacted to give effect to Article 21A. For the above reason, since the Article 19(1)G is right, right is not an absolute right as Article 31, 2009 Act cannot be termed as unreasonable. Now your lordship may come to page para 38. Para 38. The 2009 Act not only encompasses the aspects of right of children to free and compulsory education, but to carry out the provisions of 2009 Act. And it also deals with matters pertaining to establishment of the school as also grant of recognition under Section 18. Thus, after the commencement of the 2009 Act, the private management intending to establish a school has to make an application to the appropriate authority, and till the certificate is granted by that authority, it cannot establish or run the school. The matters relevant for the grant of recognition are also provided for in Section 1925 read with schedule to the Act. Thus, after the commencement of the 2009 Act, by virtue of Section 12(1)(c), read with 2 and 4, the state, while granting recognition to the private unaided minority school, may specify permissible percentage of seats to be earmarked for children who may not be in a position to pay fees or other charges. Now, your lordship may come to
What happens?
para 53. Para 53. On reading, I'm sorry. Lordship, I come to para 58, my lord.
58.
Yes, my lord. There it considers, my lord, the validity of 2009 Act
Yes.
for unaided minority schools. The heading itself is the applicability of 2009 Act for unaided minority schools. Lordship may see para 58. Your lordship has got it. The right established by Article 30, Clause 1 is a fundamental right declared in terms absolute, unlike the freedoms guaranteed by Article 19, which is subject to reasonable restrictions. Article 30, Clause 1 is intended to be a real right for the protection of minorities in the matter of setting up of education institutions of their own choice. However, regulations may lawfully be imposed either by legislative or executive action as a condition of receiving grant or recognition. However, such a regulation must satisfy the test of reasonableness, and that such a regulation should make the education institution an effective vehicle of education for the minority community or for the persons who resort to it. Applying the above test in Siddharth by State of Gujarat, this court held that the rule authorizing reservation of seats and threat of withdrawal of recognition under the impugned rule is violative of Article 30. The above well-settled principles have to be seen in the context of the 2009 Act, enacted to implement Article 21A of the Constitution. At the very outset, the question arises for determination is what was the intention of Parliament? Is the 2009 Act intended to apply to unaided minority schools. The court was not considering Section 12. In answer to the above question, it is important to note that in PA Inamdar, this court held that there shall be no reservations in private unaided colleges and that in our regard, there shall be no difference between minority and non-minority institutions. However, by the Constitution Amendment 2005, Article 15 was amended. It is given Article 15(5). The result is PA Inamdar has been overruled on 2 counts. Whereas this court in PA Inamdar had stated there shall be no reservation in private unaided colleges, the amendment decreed that there shall be no reservations. Whereas this court in PA Inamdar had said that there shall be no difference between unaided minority and non-minority institutions, the amendment decreed that there shall be no. Now, my lord, may I just pause here for a second, my lord, because what really happened was para 68 of TMFI created a confusion as to whether the state has got the right to introduce reservation in unaided schools and colleges. So therefore, my lord, the matter, my lord, in Islamic Academy, this honorable court took the view that yes, state has the power to provide for reservation in all education institutions, including unaided schools. That was doubted, and the matter was referred to 7 judges. And one of the main question which was referred in TMA, in Inamdar, was whether the state can impose its policy of reservation in any unaided education institution. Finally, it was answered in favor of the unaided institutions and said that state has no power. Consequently, my lord, the parliament amended and introduced Article 15(5), and the parliament was very conscious of Article 30. Therefore, minorities were exempted from the purview of reservation. Therefore, my lord, it is in that context, my lord, it has been said so. Now, para 61. Article 15(5) is an enabling provision. It is for the respective states either to enact legislation or issue an executive instruction providing for reservation except in the case of minority education institutions referred to in clause 30. The intention of the parliament is that the minority education institutions referred to in Article 30 is a separate category of institutions which needs protection of Article 30, and viewed in that light, we are of the view that unaided minority schools need special protection under Article 31. Article 30 is not conditional as Article 19(1)(g). It is in a sense, it is absolute as a constitutional framers thought that it was the duty of the government of the day to protect the minorities in the matter of preservation of culture, language, script, establishment of education institutions, etc., etc. Reservation of 25% in such minority schools result in changing the minority character of the institution. The right to establish and administer such school flows from the right to conserve the language, script or culture, which right is conferred on such minority schools. Thus, the 2009 Act, including 12(1)(c), violates the right conferred on such unaided minority schools under Article 30, Clause 1. Now, my lord, last portion, para 64. Accordingly, we hold that Right to Free and Compulsory Education Act 2009 is constitutionally valid and shall apply to the following, etc. Now, my lord, then, my lord, they said unaided minorities, it will not apply. Now, what I wanted to bring to your lordship notice is para 65. However, the said 2009 Act, and in particular 12(1)(c) and 18(3) infringes fundamental freedom guaranteed to unaided minority schools under Article 30, Clause 1, and consequently applying RMD Chamar Bogwala versus Union of India principle of severability, the said 2009 Act shall not apply to such schools. Now, my lord, RMD Chamar Bogwala, my lord, clearly says if an act is challenged and if some provisions of the act is unconstitutional, some provisions are actually constitutional, then the court can apply the doctrine of severability to sever the constitutional portion from the unconstitutional portion. That is the exact test which the 3 judges applied in this particular case. The court considered whether Section 12 can be segregated from the rest of the provisions of the Act. The 3-judge bench finally found that it cannot and said the entirety of the Act has to go. Therefore, this exercise is already done by the 3 judges bench. It is, and 3 judges have come to the conclusion the other provisions in the Act are integrally connected to Section 12. It cannot be severed. That is why, my lord, the learned Attorney General submitted before your lordship that the whole thing arises out of free and compulsory education. Everything is incidental to that. So, for Section 12 read with Section 3 is the core of the Act. Other provisions are only incidental to that. And 23, 18, etc. cannot be severed. That is what 3 judges bench of this honorable court has already, this exercise is already done. So my submission before, and this is left undisturbed by the Constitution bench. Possibly it is because of that, my lord, the Constitution bench did not actually go separately into each and every provisions in the Act. Therefore, my respectful submission before your lordship is that today, my lord, I understand, my lord, teachers have to be of certain standard. It is state has the right to regulate. I am not canvassing that minority institutions are not bound by the qualifications to be laid by the state. Throughout, this court has said qualification is a necessary regulation on a minority rate. I am not opposing it. I am only saying that it cannot be done through the route under 23. It may be done through any other route.
Mr. Chacko, react to this.
Yes, my lord.
Please have 12C with you.
Yes, my lord.
RTE Act 12C.
Yes, my lord.
To the extent of at least 25% of the strength of that class, children belonging to weaker section and disadvantaged group in the neighborhood, and
Yes.
provide free and compulsory elementary education till
Yes.
graduation.
Yes.
Let us assume that there is a school established and administered either by a linguistic minority or by a religious minority,
Yes, my lord.
and they are unaided,
Yes.
completely unaided,
Yes, my lord.
but they charge substantial fees
Yes, my
from
lord.
students. And the fees are such that only people from
Yes.
an affluent society can afford
Yes,
to
my lord.
have their children admitted there. Now, if under 12C, the government says
Yes, my lord.
that 25% has to be reserved for people coming from your community.
Yes.
There are weaker sections in your community
Yes.
who cannot afford education in your school.
Yes.
Only people from your community will be admitted. How does 12C conflict with Article 30?
No, my lord. In fact, my lord, that is already done. That is being done by most of these minority institutions.
No, has this been considered in Pramati?
No, that there was no occasion to consider it, my lord.
Why not? This should
No,
have
my
been
lord.
a question.
No, my lord.
If
Now,
the court went beyond the questions which were formulated, as you just now said, this would have been one of the relevant questions. Why a weaker section, backward section, Christian, Muslim, any other community?
No, my lord. In fact,
Why can't they enforce this right that I come from the weaker community? I don't have
Yes.
the financial capacity, but
Now-
I want my child to be imparted education by this school.
now I'll tell you, lordship, my lord. I can.
Going against the wisdom of 21 capital A.
Now, I will tell your lordship, my lord, from my experience, I can tell your lordship, my lord, irrespective of the particular religious status of the student concerned, my lord, most of
Right.
these minority institutions are actually giving free education. And what they do is, my lord, I know, my lord, what they do is, particularly the sisters, my lord, they make a verification. They go visit the houses to verify that it goes to the right person. On the contrary, my lord, under the Right to Education Act, my lord, if a particular parent produces a certificate issued by the Tahsildar, the school management is bound to provide free education to that particular child, irrespective of the economic status of that child. They have a better regime.
We
Yes.
are not questioning what you're doing. In fact,
Yes.
I was telling my brother that, for instance, Xavier's has now become a Hindi medium school just to
Yes.
cater to the lower strata of the
Yes, my
society.
lord. Yes.
I understand that. We are testing a legal proposition.
Yes,
We are
my
not saying that you're not doing it.
No, that's right, my lord. And now, my lord,
We are only testing a legal proposition.
Yes,
We are
my lord.
asking you whether this was done by Parliament, would it be constitutional and legal or not? That's all. Whether you're doing it on your own, we are not getting into that. We appreciate what you're doing.
And there is always a presumption, and every effort must be made by the court to sustain the provision under challenge.
Now, my lord, I am today, my lord, the only question which arises for consideration whether the notification under Section 23 can apply. Therefore, my lord, my only submission, my lord, this exercise may not be required. There may not be any requirement to refer this matter to a larger bench because for the reason that particularly, my lord, Tamil Nadu, my lord, it is already done. 2023, my lord, that is already done. And my lord, other states also, as far as I know, my lord, most of these
Once it
states.
has been brought to our notice
Yes.
that in view of Pramati, RTE Act is not applicable to both aided and unaided minority institutions.
Yes.
This confusion has to be cleared.
I'll tell you, lordship, my lord, your lordship can say that, my lord,
We are
it's
not
a-
only there for enforcement of rights, but
Now
we are
your lo-
also there to safeguard the rights of others.
I would put it this way, my lord. Yes, my lord. Now, in view of Section 23, which applies to schools which are governed by RTE Act, my lord, your lordship can say all the states are bound to do it in exercise of their power under Entry 25. That is an appropriate power which is conferred on the state to do it, my lord. Your lordship can issue a direction to that effect. There is no need to do it under 23, my lord, which is already considered by this court, my lord. I understand, my lord, the teachers should be of particular standard. Now, my lord, the state has the power to prescribe certain tests, certain standards qualification is something which cannot be questioned. But there is a source which is given to the state to do that, my lord. And the states have done it or they are doing it, my lord. So your lordship can take that into consideration, my lord, for the purpose of ensuring that in a teachers of particular standard, the state ensure the standard of the teachers who are actually recruited to all the schools, my lord.
No, but Mr. Chacko, once we find that there is NT 25 in list 3,
Yes, my lord.
that means the center can always legislate.
Center can do that. Do that.
So why should we ask the state to bring about another legislation? When we find there is a legislation in place and we read this far into NT 25, then where is the problem? Why should we
No, my
ask
lord,
the state to
Today,
bring
no, my lord, it is always open to the legislature, either the parliament or the state legislature, to undertake that exercise. But I am only saying, my lord, that may not be done under 23, my lord. It can always be done in exercise of the power under 25, my lord. Either the parliament or the state legislature, because it is in the concurrent list.
So under NT 25 it has been done, no? We are putting to you that
Yes,
if the
my lord,
power
Tamil
is-
Nadu,
we
Tamil
presume
Nadu,
that
it was done in 2023, my lord. It is applies to minorities also. They have done it. All states, when they do it, my lord, it applies to everybody. They don't give any exemption. Exemption is actually given if it is an exercise under section 23 or under the RTE Act. So therefore, my lord, there is no need to introduce this through the route of RTE Act. There are other sources from which it can be done. It is being done, or your lordship may pass appropriate directions, my lords.
No, why directions are required? It's a covered field.
No, correct, my lord. Then, my lord, the state, at any rate, my lord, the states are doing it, my lord. There is no need.
They're also in agreement. See, everyone is in agreement that the child deserves the best teacher.
Correct.
That
Now,
there is no issue about it. So why?
There is one more aspect, my lord. I am only testing it, my lord, which is that, my lord, the quality of the teachers which are required to impart free and compulsory education stands on a different footing. Because, say, for example, a school which is governed by the RTE Act, my lord, 25% of the students come from economically weaker sections. And my lord, 75% belong to other sections of the. Therefore, my lord, the teachers should be able to blend this 25% with the remaining 75%. That is what is actually contemplated in section 23. So therefore, 23 will apply only to a school which is governed by the RTE Act, by the RTE Act, my lord. Therefore, my lord, section 20, this is what I want to submit. So the teachers' eligibility contemplated under section 23 will be different from teachers' eligibility insofar as other schools which are not governed by the RTE Act are concerned. Therefore, there has to be different considerations. It can't be said that the standard of a teacher contemplated under section 23 is the same as the standard of a teacher who is bound to follow these eligibility tests under a different enactment. Because the purpose of these enactments are different, my lord. The purpose of a School Education Act is different from the RTE Act. Therefore, my lord, what I beg to submit is, my lord, perhaps some other standards can be laid down when the state exercises its power under entry 25 of list 3.
As you are saying, state has also framed the same requirement.
23 in Tamil Nadu, they did it in
They have done
2023.
the same thing. So it's not that it is just confined to 25%.
No, in
EWS,
fact,
but it
no,
is-
in
it
fact,
is
I'll tell
confined
you,
to
lordship.
schools today. And see, we have pointed out other provisions like teacher-pupil ratio. How can you say that in minority institutions you will not follow that ratio?
That ratio is followed, but because the CBSE regulations are there, executive instructions are there of the state government. Every school is actually bound. But what is practically the same thing which is provided in the RTE Act? This is already taken care of. There are regulations by the CBSE, ICSE, everybody, my lord.
Maybe they have placed it at a higher pedestal. It should be recognized at a higher pedestal. Why
No,
not?
my lord. No, my lord. This is,
It
in
talks
fact,
about, it talks about parents association, how
Yes.
they will interact with the teachers. Everything is stipulated in this act.
Teachers' grievance mechanism.
There's a teachers grievance mechanism. There's a lot of issues over here.
correct, my lord. In fact, my lord, it is always open to the state.
You know, although
Yes, my lord.
RTE Act 2009 refers to Article 21 capital A as its source.
Yes.
But if you read the entirety of the RTE Act as well
Yes,
as the
yes.
rules framed thereunder, you know, we can safely hold that it is not only restricted to free and compulsory education, but it extends to various other aspects, and the source whereof can be traced to NT 25.
In fact, my lord, in which case, my lord, it has to be declared as ultra virus 21A. It can't be the other way, my lord. Because
Why?
Why
and-
21A?
and the act is actually enacted to give effect to
So
21A.
you can have two sources.
No, my lord,
Where is
but
the
the
problem?
government,
If a
no, my lord,
particular act has two sources.
what the stand taken by the union government is that it is only under 21A. This is a legislation enacted only under
It's a
21A.
stand that can be taken by any party, but
Yes, my lord.
he have to lay down the law. We find that it can be traced to both 21 capital A and NP 25.
Now, my lord, at the time of passing this legislation,
You tell us, what does teacher redressal mechanism has got to do with within the narrow confines of free and compulsory education?
now, my lord, that is what I am submitting, my lord. All these
So
provisions.
therefore, cumulatively, it has to be seen whether the RTE Act, which has now been enacted, whether it is competent for the Parliament to have done it or not.
Now, my lord, your lordships can observe, my lord, similar provisions. Can the other legislatures, state
And
legislatures?
more you argue, we are thinking that we should explain the judgment instead of sending it to a larger bench.
No, my submission is, my lord, this is something which your lordship can decide without referring to a larger bench, my lord. Within the confines of the two judgments, my lord, this is an exercise which can be done by your lordship. There is no need to refer the matter to the larger bench, my lord.
Then
That's
let
all I
there be
want.
clarity, no?
Ah.
Let there be clarity once and for all.
I leave it to your lordship, my lord.
We feel that something has been overlooked, so let it be.
It may not have been in their contemplation.
No,
You know,
anything else, anything else.
We also commit this.
Yeah.
We are thinking in a particular way. Now, our language is open to interpretation, and lawyers are there. They will interpret in 10 ways. It's not necessarily the way I intended it to be read.
See, the matter was argued from a specific perspective, and it was examined from that perspective alone.
We cannot criticize these judges
Ah,
that they
correct.
have committed a wrong.
No.
That is mainly, I'll tell you, lordship, what happened because act was already upheld by the three judges. Therefore, my lord, and then, my lord, what the constitution bench considered is only validity of 21 and 15.5. So, incidental
correct.
to that, the
That's
court
the
also.
point.
Yes.
They only considered the validity of Article 15.5 and 21.
And incidental to that, my lord, they considered the validity of
That's all.
the act also. Incidental to
They
that.
have not gone into this specifically.
No, the reason why they did not go.
Court hold of.
Well, thank you, Mr. Chairman. Yes, Mr.
Obliged, my lord. I was, no, my lord, let me clarify, my lord. I was only assisting a lordship, my lord, because I was earlier appearing for some of the institutions from Tamil Nadu. Now that, therefore, my lord, I'm grateful to your lordship, my lord, for the opportunity given to me, my lord.
But I appear in the Maharashtra matters.
You appear in the Maharashtra. Achha.
Lordship, I appear for petitioner, your lordships.
Very well. Just let us just hear Mr. Kaji. Just wait
Yes.
for a moment. He is there and he wants to make a short submission on behalf of Maharashtra. Let us.
Please, lordship.
Sir, जो जितना argument आ रहे हैं।
The issue in the present case is whether the passing of the teacher's eligibility test is mandatory for being appointed as a teacher in the minority educational.
Please, what is your good name?
Amol Chitali. Amol Chitali.
Yes.
Was the subject matter of challenge in the present appeal, which arises from Maharashtra level, is the judgment and order dated 12th of December 2017 passed by the Honorable High Court of Judicature at Bombay in the writ petition number 4640 of 2016, whereby the Honorable High Court was pleased to dismiss the challenge to the GR dated 23rd of August 2013 issued by the state of Maharashtra. The appellant herein was not a party to the said proceedings and hence filed the present appeal seeking permission of this Honorable Court. By GR dated 23rd of August 2013, issued in reference to the Right of Children to Free and Compulsory Education Act, read with notification dated 23rd August 2010, issued by the NCTE, the government of Maharashtra made passing of the TET compulsory for appointment of primary teachers. Taking note of the Constitution Bench judgment of this Honorable Court in Pramati, the Honorable High Court made a judgment dated 8/5/2015 passed in writ petition number 4640 of 2016 was pleased to hold that TET was not necessary for appointment of teachers in a minority educational institution. The interim judgment dated 12th of December 2017 though takes notice of the judgment dated 8th of May 2015 passed in writ petition number 4640 erroneously without making any reference to the Constitution Bench judgment in case of Pramati dismissed the writ petition and upheld the validity of the GR dated 23rd August 2013. There is no statute, this is an instruction I've asked my learned friend appearing for the state of Maharashtra. There is no statute enacted in the by the state legislature providing for passing of TET as a requirement for appointment of teacher in the state of Maharashtra. So, only by way of a GR, this has been done of 23rd August 2013, and there have been subsequent amendments to that GR. TET is not applicable to minority educational institutions. Mr. Chaku has made this submission in detail only on the basis of just. The Constitution Bench judgment in the case of Pramati has categorically observed that there is no conflict between the provisions of Article 21A and Article 30 of the Constitution. However, the law made in exercise of the mandate of Article 21A, namely the RTE Act, should not abrogate the right of minority institutions under Article 31 of the Constitution. It is pertinent to note that the RTE Act was amended by the RTE Amendment Act 2012, Act 30 of 2012, thereby providing that the provisions of the RTE Act were subject to the provisions of Article 29 and 30 of the Constitution. This happened after the Private Education Society's 3-judge bench. After that judgment, where it held that it is not applicable to unaided minority institutions, this amendment was brought in, and subclause 4 of Section 1 specifically says that the RTE Act will be subject to Articles 29 and 30. Further, the Constitution Bench, in the case of Pramati, has taken note of the RTE Amendment Act 2012 and has categorically held that RTE Act is not applicable to minority educational institutions. Hence, there is no question of doubting the correctness of the judgment in Pramati, and no case is made out for referring the same to larger bench. In view of the aforesaid legal position, the prescription of passing of TET as a requirement for appointment of teachers issued by the NCTE with a notification dated 23rd August 2010 or by any state government in exercise of provisions under Section 23(1) of the RTE Act cannot be made applicable to minority educational institutions. Now, it's on the nature of this TET. The TET is
What
not
is subject to the provisions of 29 and 30?
that's it. Well, subsection
Subject to
4.
provisions.
So
In
that
a way, it does not offend the fundamental rights guaranteed by 29 and 30. It can be applied.
that's right. Well, it's what had happened because it was held inapplicable because it violated Article 30.
Even if we leave aside 12, we are not going into the point as to whether the CB had rightly declared that 12 does not apply. Because we are bound by that. But so far as the point which is not touched by this, why would it be regulated? This is a regulatory measure.
That's it. Well, it's on
And then KMFI has said so.
that's it. But as far as
You see that question 5C and answer at the bottom. Yeah.
that's it. Well, there is no doubt on the legal proposition as far as the monitoring of the minority educational institutions, as far as the secular aspect is concerned in terms of quality of teachers or the syllabus. Well, that issue, well, there is no the doubt on the law or the legal position. Well, it's here.
Why the TT is made compulsory across the country. All schools.
Right.
So how does it affect your minority right to administer an educational institution?
Well, it's what has been held, my lords, in all the judgments right from Kerala education is that the essential features or essential qualifications will be applicable to minority. My respectful submission, my lords, is that the TET test doesn't fall into the category of those essential requirements.
Why do
My
you
lords,
say that?
yes, my lords, I have given the reasons, my lords, my lords, it comes to paragraph C of my note. May I just read?
5C, KMFI says regulations can be faced governing service conditions for teaching and other staff
That's-
for whom aid is provided by the state without interfering with the overall administrative control of the management over the staff.
Now, this is with regard to the aided institutions. As far as the unaided minority institutions are concerned, they slightly stand on a different footing. And as far as the basic requirements for monitoring the excellence in education is concerned, they are bound by it. But in my respectful submission, what can be done is that if there are basic requirements which are necessary for maintaining the standard of education, it would be applicable.
This
But-
falls in that pigeonhole itself.
My lords, we just see that my point C. I have explained how this.
Actually, you're right. But it falls in that pigeonhole. What do you?
Yeah, yeah. Well, that is what I'm endeavoring to show. Section 23 of the RTE Act provides that any person possessing such minimum qualification as laid down by the academic authority shall be eligible to be appointed as a teacher. By notification dated 31st March 2010, the NCTE was notified as an academic authority to lay down the minimum qualifications for the person to be eligible for appointment as a teacher. Resultantly, the NCTE Act came to be amended and Section 12A came to be introduced by Act 18 of 2011 with effect from 1/6/2012. The NCTE was empowered to determine the qualifications of persons for being recruited as teachers by way of regulations issued under Section 32 of the NCTE Act. In terms thereof, the NCTE issued notification dated 23rd August, October, it should be August, it's a typo, 2010, prescribing minimum qualifications for a person to be eligible for appointment as a teacher in class 1 to 8 in a school referred to in Section 2N of the RTE Act. The NCTE in the said notification also prescribed passing of TET as the requirement for such appointment. The issue that arises in these facts and circumstances is whether the requirement of passing TET can fall within the ambit of minimum qualifications for a person to be eligible for appointment as a teacher. It is pertinent to note that there is a distinction between minimum qualifications required for being appointed as a teacher and passing of an eligibility test. Minimum qualifications essentially refer to educational qualifications which are mandatory for being appointed as a teacher, that is educational qualification, without which such a person cannot be appointed as a teacher. While TET is designed to assess the aptitude of a candidate for the profession of teaching. The guidelines dated 11th of February 2011 were issued by NCTE for conducting TET. Clause 3 of the said guideline outlines the rationale behind the prescription of TET. The same is as under. The rationale for including the TET as a minimum qualification for a person to be eligible for appointment as a teacher is as under. It would bring national standards and benchmark of teacher quality in the recruitment process. It would induce teacher education institutions and students from these institutions to further improve their performance standards. It would send a positive signal to all stakeholders that the government lays special emphasis on teacher quality. The said guidelines further provide that the examining body shall take into consideration and focus on understanding the characteristics of the need of diverse learners, interaction with learners, and the attributes and qualities of a good facilitator of learning. It is thus submitted that taking into consideration the rationale behind holding the TET, it certainly cannot fall within the scope of ambit of minimum qualification required for being appointed as a teacher, but is helpful to assess the aptitude of a candidate for the profession of teaching. Though such an assessment is desirable, it cannot take the character of mandatory minimum educational qualifications required for being a teacher. It is because of the aforesaid reason that the TET is not a mandatory requirement but merely directory in nature. The directory nature of the TET is further evident from the following factors. Namely, as per the notification dated 23rd of August 2010, TET is prescribed for teachers seeking appointment for class 1 to 8. TET is not prescribed for appointment of teachers for classes beyond 12, beyond 8, despite the fact that section
Beyond
28,
3.7.
sorry, that's a type. Despite the fact that Section 12A authorizes NCTE to prescribe qualifications up to intermediate and school and college level. Clause 3 and 4 of the notification dated 23rd August 2010 itself carves out an exception.
Because it is still 14 years of age. It is still 14
That's
years.
smallest, but from the
Class 8 you require it. You are referring to 12A of the NCTE Act.
Yes,
That is for a different purpose.
that's my submission is.
Either application 12A of the NCTE Act.
Well, my submission is that this TET, which is made applicable only till class 8.
But beyond that, there are other qualifications. It's not that they have not laid down qualifications. Beyond class 8, they are separate qualifications. In fact, higher qualification than TET.
First, there are two aspects in the notification. One is the qualification. Even for the appointment of a primary teacher, there are qualifications prescribed in the notification. B.Ed, D.Ed with 50% and all those. In addition to that, a TET has been prescribed only for classes from 1 to 8. And so if it was an issue of quality of teachers, and if the TET test was to be attributed with the purposes of assessing the quality of teachers, my lord, it should apply across the board. It cannot be said that only for the teachers of primary school, we need to assess whether they're of good quality. But when it comes to the classes,
High qualification prescribed, no, in level 4.
first qualifications are there.
At
Definitely,
least 50% marks in either graduation or post-graduation.
that's true, my lord.
And Bachelor of Education from NCTE,
That's
recognized this.
well, it's
So it's a
qualification.
high qualification.
Yes, qualification, because if you are teaching for a primary school, you require a certain level of qualification. If you are teaching for classes beyond primary, there are certain other sets of qualification. But in addition to the sets of qualification, only for classes 1 to 8, there is a provision for TET. And for the other classes, there is no such provision. Right? So if it was a requirement for quality assessment, then it should apply across the board. It can't be said that only teachers for class 1 to 8 have to be of a higher quality, and from 9 to 12 onwards, you don't require teachers of good quality. So in that sense, my lords, I'm saying that this TET doesn't fall within that minimum qualification which is required under Section 23. There is no provision in the NCTE Act prescribing for consequences of non-compliance of the requirement of passing TET examination. This clearly goes to show that the said requirement is merely directory and not mandatory. Whether passing of TET is necessary for promotion in respect of teachers appointed prior to 23rd of August 2010 is also doubtful in terms of notification issued by the NCTE. In the state of Maharashtra, the requirement for passing TET examination was introduced by the GR dated 13th February 2030. Clause 7 of the said GR prescribed passing of the TET even for teachers appointed prior to the said GR, and such teachers were given time till 31st of March 2015 for passing the TET. However, the said clause came to be deleted by the GR dated 6th of March 2030. So, my lords, therefore, my respectful submission with regard to the nature of TET is that it is not a test which comes under Section 23, because Section 23 talks about minimum qualifications which are to be prescribed by the authority. And those minimum qualifications have been prescribed. We are following those qualifications. But in addition to that, only for classes 1 to 8, there is a requirement of TET which is prescribed, and which again is not a mandatory procedure. But as far as the competing rights is concerned, issue number D, the primary conflict of rights which arises in this case is with regard to the right of children to have quality education as against their right to have education at all. In pursuit of providing quality education, the right of children to receive education has been compromised in the present case. The passing percentage in the TET examination all over the country has been abysmally low. As a result, the number of teachers eligible for appointment has substantially reduced. The stand taken by the NCTE in the present proceedings in respect of removal of teachers who are already in service and have not passed the TET would further result in shortage of teachers. On the other hand, because of introduction of RTE Act, the requirement of teachers has significantly risen.
This is not correct, no? Factually not correct, because Mr. Nadkarni has told us that there is surplus TET teachers
As far
in
as
state of Maharashtra.
As far as
You are appearing in state of Maharashtra.
no, but this applies to the entire country, Maharaj. And the state of Tamil Nadu specifically made a submission.
No, but you are
that there are no
appearing in
teachers.
Maharashtra.
This act applies to the entire country, so we have to take that into consideration. Section 25 of the RTE Act, academic schedule, provides for a pupil-teacher ratio. Taking into consideration the increasing number of students covered under the RTE Act and the requirement of the pupil-teacher ratio prescribed therein, well, there are about 2 teachers for every 30 students. That is what the schedule prescribes. That is the requirement of pupil to prescribe therein. Insistence on passing the TET examination would in fact be counterproductive to the aims and objects of the RTE. In case of minority institutions, the situation is further worsened because of the introduction of the TET. It is a settled legal position that employing teachers compatible with aims and aspirations of the minority education institution is a facet of Article 30 of the Constitution that is held in Xavier's case. With a shrinking pool of such teachers applicant to the cause of the institution because of introduction of TET, the rights of minority education institution guaranteed under Article 30 have been eroded. That's my respect. As far as Pramati is concerned, members, there is no dispute with regard to Article 21A and Article 30. Now, this Honorable Court has categorically held that there is no dispute with regard to, there is no conflict with regard to 21A vis-a-vis Article 30 rights. But the 21A has to be expressed by way of a legislation. And that legislation has to be in consonance with Article 30. And that is why, my lords, Section 1, subsection 4 of the RTE Act also specifically says that this has to be in light of Article 29 and 30. So that's my response. I'm grateful.
Yes, Mr. Kazi.
Please, Your Lordships. I appear for the petitioner, Your Lordships. Lordships may kindly consider the petitioner is
Which matter?
in 101, Your Lordships. That is Anjuman
Pertaining to Maharashtra only. Your Lordship.
Okay, this is also Maharashtra.
Maharashtra, yes, Your Lordships.
It's a minority.
The
So you are
petitioner,
adopting Mr. Chitale's submissions, and in addition, what do you want to say?
yes, Lordships may kindly consider the Aurangabad bench white judgment and order dated 8th of May 2015, which is at page number 102. Lordships may kindly refer of the SLP, Your Lordships.
Which SL?
101. Item 101, Your Lordships.
No, is it there in the compilation?
Yes, yes.
101 is coming from Tamil Nadu.
101.1, Your Lordships.
What is
0.1.
101 is Maharashtra.
Maharashtra, yes. Anjuman Ishate Talim Trust.
Maharashtra? 101?
Yes.
And 101.1. Because those have been 101.1.
Those were withdrawn, Your Lordships. 101, yes.
Matters have gone.
Yeah, yes. So 101 may kindly be referred, Your Lordships. Page number 102, first of all.
We are looking at Civil Appeal 1386, Association of Urdu Education Societies. Is that the SLP?
Lordship, no. Mine is Anjuman Ishate Talim Trust.
What is the number today in the list?
101, Your Lordships, that is.
No, 101 has several.
Anjuman Lordship 101 है main matter.
So 101 वही देना?
101. नहीं ऊपर ही है 101 नीचे वो सबसे नीचे ये वाला
Lordships may kindly refer page number 102, Your Lordships, first of all.
One?
102.
102.
Yes.
Yes.
The Aurangabad bench of Bombay High Court decided writ petition 1164 of 2015.
Right.
Para 2, I'll read. The petitioners are aggrieved by the impugned communication dated 24/11/2014 issued by Education Officer Primary Zilla Parishad Aurangabad, thereby refusing proposal dated 20th May 2014 seeking approval to appointment of Shri so and so, who is working as assistant teacher in petitioner's institution on the ground that said teacher has not passed TET. Now, I'll skip over, Your Lordships, few paras, and thereafter from para 5 onwards, Your Lordships. We have given careful consideration to the submissions of learned counsel for the parties. With their able assistance, perused the grounds taken in the petition, the contents of the impugned communication and all other material placed on record. In the light of the judgment of Supreme Court in Pramati case, it is not necessary for us to elaborate any further on facts. Suffice it to say, the impugned communication issued by respondent number 3 is not legally sustainable in view of authoritative pronouncement of Supreme Court.
Of course, they were bound by this judgment.
Yes, Your Lordship. Now there.
How the mind of the bench was influenced, you will see only within quotation. The last part is quoted, not the entire paragraph. But in any event, they were bound by what the Supreme Court.
Yes, Your Lordship. Thereafter, this judgment was followed throughout the state of Maharashtra for more than 2.5 years. But while passing the impugned judgment, Your Lordships, which is at page number 1.
Yes.
In writ petition 4640 of 2016, the Honorable Division Bench at Principal Seat at Bombay had taken a different view, Your Lordships. If para 8 is perused, Your Lordships, at page number 4, though this judgment was cited, para 8, apart from that, a similar issue arose before Division Bench of this court in writ petition 1164 of 2015. The division bench held that the schedule to teachers eligibility test as well as various government resolutions issued by the state government with regard to the staff etc. do not infringe the rights of minority institutions to administer according to their own choice. We find that applying the same analogy, no fault is found with the government resolution dated 23rd August 2023. The petition is without merit, the petition dismissed as such. So these observations in para 8 are contrary to the judgment and order which is passed in petition 1164 of 2015 at page number 102, Your Lordships. Lordships may kindly consider the impugn order is passed in violation of principle of stare decisis. The judgment of Aurangabad bench having same strength was binding, Your Lordships.
And they will rise, right?
Yes.
So therefore, Your Lordships, we are aggrieved because being a minority institution already, the petitioner has obtained an order, though the petitioners were not a party to the impugn judgment, but this honorable court granted leave and therefore this SLP is converted into appeal, Your Lordships. So it is our contention that as per the provisions of RTE Act, Lordships may kindly consider para 1 subclause 4, section 1, I'm sorry, section 1 of the RTE Act, subsection 4, which excludes the minority institutions from the purview of this right of children to free and compulsory education act, Your Lordship. I'll just read section 1 subclause 4.
Was this impugn judgment stayed by this court?
Yes, Lordships, this impugn judgment status quo was there, Your Lordship. So
By which order? Which date?
Lordships,
Because
in
notice
Lordships, status quo was granted in another group of
6 October 2018, there is no stay. Thereafter, was it stayed?
Lordships,
And if it has not been stayed, what have you been doing for the last 7 years?
Lordships,
You have a judgment, you are bound by the RTE Act.
Lordships, in another group of petitions by which the petitioner in this impugn judgment, that is Azad Education Society, has preferred SLP. A group of petitions are merged with that, and in that status quo is granted, Your Lordships.
Lordship, there are 4-5 matters which has been tagged. The other group is there, Your Lordship, that this judgment has been challenged by the Azad, the petitioner.
Their status quo has been ordered.
Your Lordship, I have to verify because that is not.
And Lordships may kindly consider even.
This is the main appeal.
Yes.
And in the main appeal, we don't find that there is. So therefore, Azad, bound by the division bench judgment of the Bombay.
Please, Your Lordship.
And Lordships, the Honorable Bombay High Court has also constituted larger bench, as there were two different views taken by the two different division benches, and before the larger bench also the issue is pending, Your Lordships.
Very good.
So I would submit, Your Lordships, as per the provisions of section 1 subclause 4, when the article 20, it is subject to article 29 and 30, meaning thereby, Your Lordships, the minority institutions are excluded from the purview of the right of children to free and compulsory education act, and the Honorable Supreme Court has already in Pramati education.
So we put the same question to you. It says subject to the provisions.
Yes, Your Lordship, subject to the provisions of article 29 and 30 of
It
Constitution.
does not offend the right to establish and administer. RTE Act will apply. Now today, there is one section
Yes.
that if you want to establish a new school,
Yes,
you
Your
will
Lordship.
have to obtain the recognition from the board.
Yes.
Now, can you read section 1, subsection 3 of the RTE Act in a manner that you will have the right as a minority, either linguistic or religious,
Yes.
to establish a school and not take the recognition?
Lordship, the recognition is to be obtained from the state for.
See section 18 of the RTE Act.
Lordship, it shall, subsection 3 says it shall come into force on
Come to
such day.
section 18,
Section 3.
18 of
18.
the RTE Act.
Please, Your Lordship. 18. No school to be established without obtaining certificate of recognition. No school other than a school established, owned or controlled by the appropriate government or the local authority shall, after the commencement of this act, be established or function without obtaining a certificate of recognition from such authority by making an application in such form and manner as may be prescribed.
So today, if I want to establish a minority institution,
Yes, Your Lordship.
can I say that in view of section 1, subsection 3 of the RTE Act, I am not required to obtain the permission under 18?
Lordships,
Can
as
you
Your
argue
Lordships,
to that extent?
Lordships, as the Honorable 5 Judge bench.
Sir, don't rely on the 5-judge bench. We are putting you a simple legal question.
Yes, Your Lordship.
What does subject to the other provisions mean?
Yes, subject to the other provisions, yes.
There is no provision in the RTE Act that this RTE Act does not apply to minority institutions.
Lordship, then I would submit, yes, in order to clarify this point, Your Lordship, I
Or
would
on that,
submit.
notwithstanding the provisions of this Act, this does not apply.
Lordships may kindly consider so far appointment of staff is concerned.
Mr. Kasi, please give your submissions in a 3-page written note. And this is our request to all council,
Yes.
because we will follow what has been followed in Pramati. We will set out the submissions from the written notes.
Please, Your Lordship, I'll give.
Give our
Only-
reasons.
In this context, may I point out
Lord,
that Milords, the provision under Milords section 2C, which defines what is a child under the RTE Act, and Milords read with section 3, which talks about a child. Milords, the emphasis under the RTE Act, but as already elaborated by the learned Attorney General, was that Milords, the entire enactment is an offshoot of Article 21A and it has to be read in its entirety as one scheme. If your Lordship kindly sees 2C, Lord, it says, Lord, which your Lordships have also read, Lord, the earlier portion which says subject to 29 and 30, provisions of this Act shall apply to conferment of rights on children to free and compulsory education. Then if your Lordship sees 2C, 2C simply says child means a male or female child of the age of 6 to 14 years. D, Lord, is child belonging to disadvantaged group, which includes a child with disability. And Lord, thereafter, child belonging to weaker section, child with disability, including Lords, all these categories. Therefore, the emphasis is on a child. And Lords, a child cannot be distinguished, Lord, whether he is studying in a minority institution or Lords, whether a non-minority institution. Moreover, now Lords, the Union government has adopted the policy of inclusive education with respect to children with disabilities. They have discouraged Lords, the opening of new schools even at the government or government aided level, which are special schools. And every child is supposed to be Lords, admitted in all schools, non-minority and minority. But then if your Lordship sees in that context, section 3, every child of the age of 6 to 14 years, including a child referred to in clause D or clause E of section 2, shall have the right to free and compulsory education in a neighborhood school till the completion of his or her elementary education. So, Lord, nowhere there can be any distinction with respect to this. And if your Lordship also sees the duties of an appropriate government under section 8, under section 8G, it says to ensure good quality elementary education conforming to the standards and norms specified in the schedule. And in fact, in Tamil Nadu, Lords, in volume 4, Lords, I had mentioned the Tamil Nadu rules. There also there is a specific rule 8 which says that there shall be no distinction between students who are admitted under the 25% quota, and all of them will have to be treated, will have to be taught together in one classroom. You cannot have any discrimination or distinction or any idea of having them as a separate class, even for the purpose of teaching, whether they belong to disadvantaged categories, disability, or weaker section.
Right.
And in fact, if your Lordship sees section 12 of the NCTE Act, section 12C, 12(1)C of the NCTE Act, which had the functions of the council. A question was raised in the earlier proceedings as to whether the NCT had any power to determine the minimum qualifications of teachers even prior to the introduction of 12(A), which came only in 2011. For that, the answer is found in section 12, In 12(1)(c) it says, Lord, it is the duty of the council to coordinate and monitor teacher education and its development in the country. And D, lay down guidelines in respect of minimum qualifications for a person to be employed as a teacher in schools of
Sorry, where you are reading?
She's from NCT Act.
You are reading
NCT Act. NCT Act, Lords.
NCT Act. Yes.
Yes. NCT Act, which is volume 5.
Yes.
Sorry, Lords, I did not refer to that. Which is at page 7, Lords.
Yes.
Page 7, section 12.
No,
Functions of the
Kavita,
council.
you should have waited for your rejoinder.
Only to clarify on this point, Lords, only on the aspect, I'll file my Lord,
Yes,
submissions
please,
in
please.
this also. Lord, if your Lordship sees 12(1)(c) and D, D says lay down guidelines in respect of minimum qualifications for a person to be employed as a teacher. Lord, the words in schools has now been deleted under the Act 18 of 2011 because, Lords, they took those words out and they made a detailed provision under 12 capital A. But earlier, that was what was there. From 1993 to 2011, it was part of the functions of the council to lay down minimum qualifications for teachers in schools also. And if your Lordship sees the entire scheme of the NCT Act also, under section 14, they have to obtain recognition from the NCT. But all these provisions, Lords, will be dehorse the rights of the minority institutions under Article 29 and 30. In fact, again, since your Lordship is referring to that Act note, page 15 also, section 32. Power to make regulations. In that, in 32(2), clause D, Roman 1. The norms, guidelines, and standards in respect of the minimum qualifications of a person to be employed as a teacher under clause D of section 12. And 4, standards in respect of examinations leading to teacher education qualifications. Not well before the coming into force of 12 capital A, etc. But we already had the judgments of this Honorable Court Lords in Mao Vaishno Devi and in Sandhyaneshwar, where they have examined everything in detail and held, Lords, how NCT is the apex authority as far as teacher education as a whole is concerned.
Very
Well, just only on the aspect of subject to clause 29 and 30. This paragraph 39 in Pramati's judgment.
Paragraph
39 in Pramati's.
Paragraph 39.
The timing of the document is very crucial. That is taken note of in paragraph.
No, it came after that judgment.
That's Society of Rajasthan Private Education, which held that the RTE Act is not applicable to unaided minorities. Bottom, my lords, the two learned judges, the Justice Manmohan.
Yes.
The two learned judges, however, held that the 2009 Act, in particular section 12(1)(c) and section 18, infringe the fundamental rights guaranteed to unaided minority schools under Article 30 of the Constitution, and therefore the 2009 Act shall not apply to such unaided minority schools. Differing from the majority opinion expressed by the two learned judges, Radhakrishnan J. held that Article 21A casts an obligation on the state and not on unaided non-minority and unaided minority schools to provide free and compulsory education to children of the age of 6 to 14 years. After the aforesaid judgment of this court in the Society for Private Unaided Schools of Rajasthan, the 2009 Act was amended by the Right of Children to Free and Compulsory Education Amendment Act 2012, Act 30 of 2012, and by the amendment it was provided in subsection 4 of section 1 of 2009 Act that subject to the provisions of Article 29 and 30 of the Constitution, the provisions of the 2009 Act shall apply to
What does this mean?
well, it's in the normal, in the normal sense that
There is total exclusion.
absolutely. But my lords, when this was read with the judgments in private Society for Private Education Institution, which held that this act is not applicable to unaided minority institutions.
We'll continue at 2. We'll continue at 2. Sorry to interrupt you because within 5 minutes we have to finish this matter. Mr. Attorney, we'll start at 2 after Mr. Chitale comes. Yes, Mr. President, what is your?
Actually, well, my instructions are two things. One thing is, first argue that this is not in the discharge of duty, and second, alternatively, go under 218 of the BNSS, because there's a time limit of 120 days there, and BNS will apply now because of the procedural
218 of
BNSS.
218 of.
This is the old trials. This is the
Except 987.
This is only the old CRPC will apply.
No, it will not apply.
Yes.
531, my friend probably is relying on 531.
Yes.
This is not part of investigation. It is not part of those things.
Even inquiry and trial is included.
No, it's not. It's not inquiry. Sanction, obtaining of sanction is not inquiry or trial. It is. And the judgment of this honorable court as obtaining sanction is not part of investigation. 531. 531.
218.
218. Yes, yes. This is 218. But 218 is similar to
197.
197. There's no dispute.
Then
Now kindly have a look at 531
531.
at the savings clause.
Trial is included.
No, there's no trial.
It is
Which clause?
Let me make my submission.
not the
Kindly have a look at 531. May I read more?
Yes, yes. You start from ABC. Which one?
Now kindly just give me a minute. 531.
CRPC is repealed. Notwithstanding such repeal, ABC.
This is which is the old act. No,
PCA, he is perhaps referring to A.
Yes, ma'am.
If immediately before the date of trial, inquiry, or investigation pending,
Then such
appeal, application, trial, inquiry, or investigation shall be disposed of, continued, held, or made as the case may be in accordance with the CRPC.
now my lords, we kindly have a look. Lords.
As if this Sanika had not come into force.
This is not a trial because the cognizance is after the sanction. Sanction precedes the trial. Therefore, it's not trial. It's not an inquiry. Only issue is whether the investigation
pending.
Investigation, your lordships have heard that sanction is not part of investigation in the context of 167. There's a direct.
No, but investigation when the matter is pending.
If I
No, but after culmination of investigation, apply for sanction or nothing. Because in one case, what happened is this, that
so therefore, it would be an intermediate stage between completion of investigation
after completion of investigation
after completion
and before trial,
before trial.
which is not
So therefore, it is
Not covered.
The entire thing.
it is not covered. Therefore, that is submission.
Therefore,
Otherwise, what will happen? Our apprehension is this: if this demon fiction of 218 is not applied, then the state government is not going to grant sanction to us. That is our apprehension. I must be fair enough and point out what the apprehension is. Therefore, some time limit may be fixed.
Not the case is now.
Time limit may be fixed within which the
entire trial is over.
The result will be that please go back, Mr. Singh. Let me say.
we will consider that. What judgment you were
Yes,
Mr. Raju had appeared. He's relying on something against
No,
you.
we just found yesterday when we did not have the benefit, but we were doing our research yesterday evening, my lords. Exactly the same issue, my lords. The same reliance on these judgments, the same para 3. Yes, but the question is of law is the same.
Where is the question?
Yes, my lords. My lords,
The issue here was whether sanction is required for PMLF.
Please,
Yes.
para 3, my lords.
First respondent was VC and MD of Andhra Pradesh
Yes, industrial
Corporation. He was not a problem.
The reliance was again on Dhanova and Prakashing Badal. In para 7 and 9, my lords, it has been dealt with.
Around 9.
Yes, ma'am. 6 and 9, my lords. 6, the object of analysis must be considered here. The object is to protect public servants from prosecutions. It ensures that the public servants are not prosecuted for anything they do in the discharge of their duties. But thereafter, para 9. The second respondent was at the relevant time holding the post of Principal Secretary, INCAD, Department of the Government of Andhra Pradesh. It is not disputed that even the first respondent was a civil servant but was appointed on deputation of the corporation's vice chairman and managing director during the relevant period. It is undisputed that as far as the second respondent is concerned, he was
There even with the post of corporation.
or with the section of the government.
Let him complete.
Or with the section of the government. As far as the first respondent is concerned, we find that that is not important. Please go now, para 11. There are two conditions of applicability of section 197(1). The first condition is that the accused must be a public servant removable from his office by or with the government sanction. The second condition is that the offence alleged to have been committed by the public servant while acting or discharge, purporting to act in discharge of his duties. We have perused the decision relied upon by the learned ALC. In the case of Mohammad Haji Raja, the court took the view that the protection of section 197 CRPC will not be available to the officers of the government companies or public sector undertakings. The first respondent is a civil servant. As such, the state government appointed him as the corporation's vice chairman and managing director on deputation. And thereafter, they go on. Just one more minute. I can just complete it in just one more minute.
Para 10 is kept, para 10 is to be removed by the state government.
There are additional documents. I am appointed by the governor of the guide by the state government. And I am a public servant. There are in the act itself.
I'm not on that point.
On the Municipal Corporation Act, there are two types of officers. One my lord appointed under 74(1). I have that my lord also, the act itself, the relevant provisions. I can pass a copy. There are two types of officers contemplated. One, my lords, which are removable by the government and appointed by the government. No, that is there, my lord. It's R1 of my additional document. Yes, my lord. That is why
the appointment and then two
extension,
deputation and 2 orders of extension.
And yes, my lord. Right. They are by the governor of Punjab, and there is a distinction, my lord, in the act itself. If I can just quickly, my lord.
The order repatriating is also there?
By the governor, it is not there. I can place it on. Give me the copy, please.
What is this?
My lord, actually 71. If I go lords go one next page, my lord. Second page. It says 71(1). The administrator shall appoint suitable officers to be respectively allowed such and such, or such other officers or officers of a status equivalent to the or higher than the status of any of the officers specified earlier in this section, as the administrator may deem fit on such monthly.
This administrator is
now please see.
Governor.
Yes, he is the governor of Punjab, my lord. As far as Chandigarh is concerned, he is the
governor.
The governor.
He is known as the governor.
Yes, that notification is also there, my lord. I don't want to burden my lord with that. Now 71A, my lord. The commissioner shall, from time to time, prepare and lay before the corporation 2 schedules of the post, other than the post specified in section 71, setting forth the designations. Well, these are the officers which are not removed, which are. I am the officer in 71(1), and that is why my lord should see.
He's an executive engineer, not a municipal engineer. He's an executive engineer, my lord.
So I read with R1, my lord. I am appointed by the administrator, not by the commissioner of the corporation. And my lord, the NOVA itself makes an exception that I was reading per 9, if that one line is to be taken. For example, municipality. So it also carves out an exception itself, in example given in the judgment itself, which my friend was relying on. So, my lords, the question today is the trial is at the final stage. It is only for arguments now. Entire evidence is over. I believe it at that.
Therefore, my submission is this, my lords. We may be given liberty to apply for sanction because this is a gross case. It is not in discharge. The High Court has held it is in discharge. It is in discharge. This is a malified and dishonest act, and therefore it's not covered by the term discharge of official duties. he has favored the tender conditions as far as the award of the tender is concerned. Therefore, my lords may grant us permission as far as applying for fresh sanction is concerned under 218. If my lords feel that it is not 218, then 197 and pray. And you may be. I'm obliged.
Malad, this 155.2 also.
Not after.
I'm grateful, my lords, for
Mention item 102 notes.